Okay, well, I think now is a good time to get started. So hello, everyone. Thank you for joining us for today's webinar on the fiscal year 2022 Appropriations Public Witness Testimony. My name is Taylor Swift. I'm a policy advisor for Demand Progress. We're a non-governmental organization focusing on strengthening democracy through congressional transparency, efficiency, and modernization. In prior years, public witnesses have been very fortunate to have their voices heard by lawmakers and staff through the public witness appropriations testimony. Unfortunately, this year, House Appropriations subcommittees are not holding in-person or Zoom public witness testimonies due to the pandemic. Our organization and others are excited to have the process return to normal next year, allowing for people to testify in front of lawmakers directly. In the meantime, Demand Progress wants to ensure that people who have devoted so much time and analysis to their testimony be heard. Over the next hour and change, you will hear from about a dozen presenters, touch on a wide range of issues who otherwise would have testified in person. Each presenter will have 5 minutes to discuss their requests, and there will be no question and answer period. So with that, let's begin. Our first speaker is Eli Lehrer, president of the R Street Institute. Eli, you are now live. Go for it.
Thank you very much, Taylor. My name is Eli Lehrer, and I'm president of the R Street Institute, which is a right-of-center think tank located in Washington, D.C. I'm a conservative and a member of the Republican Party. Prior to co-founding R Street, I spent much of my career in the conservative movement. I worked at places like the Heritage Foundation and American Enterprise Institute, and I served as an executive role at the Heartland Institute. In the mid-aughts, I worked for the Republican Majority Leader of the United States Senate and had an office in the United States Capitol. There, I saw portions of the building statuary collection every day at work. I'm speaking today not as a representative of any of these organizations, but as a citizen and a conservative. I ask that the committee take all necessary steps to include appropriation language that will remove the statues of any person who held a position of importance in the government of the Confederate States of America from public display in the Capitol. Putting such statues in a place of honor is inconsistent with an accurate understanding of history, American values, and the purposes for which civilizations erect monuments. Any claim that the statues of leading people who served in the Confederacy, people like Alexander Hamilton Stevens and Jefferson Davis, commemorate heritage or history, are false. These people were traitors. They started the bloodiest war in American history because they were afraid they might lose their right to own other human beings. As our first Republican president, Abraham Lincoln, said in his second inaugural address, all knew that slavery was somehow the cause of the war. The states that left the Union as a prelude to declaring war on the United States, all of them that gave reasons for doing so, cited their desire to retain or even expand slavery. Stevens, who I mentioned earlier, was the vice president of the Confederacy. In speaking about the Confederate government, he says, its cornerstone rests upon the great truth that the Negro is not equal to the white man, that slavery, subordination to the superior race, is his natural and normal condition. These people were traitors, and honoring them in our legislative branch is inconsistent with values. These statues were elected by Jim Crow governments that violated the Constitution and American principles to deny political power and high-status careers and much formal education to African American citizens. These men did not believe that all people are created equal, nor did they wish to live in a nation where they will be judged by the color, not by the color of their skin, but by the content of their character. They wanted the opposite of these things and started a bloody war in honor of these twisted beliefs. Granting them any place of honor in the Capitol disgraces the values for which the Capitol ought to stand. I'll conclude by saying this. There are flawed people in the statuary collection. Law-abiding people who questioned, contradicted, or challenged American values are different from those who served an enemy country that intentionally killed more than 350,000 members of the United States Army on the field of battle. The truth about these men is simple. None achieved glory. All fought for a deplorable cause, and none ought to stand in the place of honor. Thank you.
Thank you, Eli. That was great. Your presentation was great, and I love that your cat is just chilling in the background, so thank you for that. Next up, we have Ginger McCall. She is the legal director for Demand Progress. Ginger, you can start your presentation now.
Thank you for the opportunity to speak here today. I'm going to submit testimony on improving transparency and accountability at the Department of Justice, Office of Legal Counsel. My name is Ginger McCall, and I'm the legal director at Demand Progress. And I'm here today to urge Congress to ensure congressional and public access to information about legal opinions rendered by the Office of Legal Counsel at the DOJ. OLC's core function, according to its own memoranda, is to provide controlling advice to the executive branch officials on questions of law that are centrally important to the functioning of the federal government. This advice may effectively be the final word of controlling law, yet it's routinely withheld from both Congress and the public. This withholding, in effect, creates secret laws that control agency actions but are shielded from both public debate and congressional oversight. Secrecy undermines democracy. Congress must understand how the executive branch interprets the Constitution and implements laws enacted by Congress. Furthermore, voters must understand how the executive branch carries out the law and who's responsible for those laws, so that they can make informed decisions at the polls and hold public officials accountable. Secrecy of OLC opinions also ensures that the most salient incentive for OLC attorneys is to lead towards a legal opinion that a given administration desires, not the legal opinion which best represents the law. This is not merely a theoretical problem. OLC has a history of rendering legal opinions that are controversial, even dubious or shoddy, from both a legal interpretation and a public opinion standpoint. One prominent example of the dangers of secrecy are the OLC opinions justifying the Bush administration's use of, quote, enhanced interrogation tactics, known colloquially as the torture memos. The torture memos, which were drafted in 2002, were secret until one of the opinions leaked to the press in 2004, after the CIA had committed numerous abuses, most famously Abu Ghraib. Once the opinions were public, legal scholars were quick to point out the poor quality of the legal reasoning. In fact, the Department of Justice's own Office of Professional Responsibility found that the authors of these legal opinions, John Yoo and Jay Bybee, had committed professional misconduct when they failed to, quote, exercise independent legal judgment and render thorough, objective, and candid legal advice. Public availability of these opinions belatedly gave Congress the opportunity to conduct its own hearings and exercise its oversight responsibilities. In a February 26, 2010 hearing on the Office of Professional Responsibility investigation into the Office of Legal Counsel memoranda, Senator Patrick Leahy noted, the fundamental question here is not whether these were shoddy legal memos. They were shoddy legal memos. Everyone knows that. The legal work of Yoo and Bybee and Stephen Bradbury, the acting head of OLC, who reaffirmed the CIA interrogation program, was flawed. It failed to cite significant case law. It twisted the plain meaning of statutes. The legal memoranda were designed to achieve an end. This is not what the Office of Legal Counsel should do, nor has ever done in any administration, Republican or Democratic. The secrecy of these opinions shrouded their legal inadequacies from public scrutiny. Without congressional or public oversight, the administration was able to rely on shoddy legal reasoning to engage in unchecked human rights abuses. Secrecy ensured that OLC attorneys were incentivized to enable the administration's questionable agenda without public scrutiny serving as a counter-incentive to provide high-quality, legally sound advice that might have thwarted the administration's torture program. When the shroud was lifted, OLC withdrew the opinions, but the damage was done. Had Congress been given timely access to the opinions, or at least been aware of the existence, Congress might have been able to better exercise its oversight capabilities to prevent Abu Ghraib and other human rights abuses. And surely senators would have also welcomed information about the drafting attorney's professional misconduct during the subsequent nomination confirmation hearings. Had legal scholars been able to scrutinize the quality of the legal analysis and offer timely critical pushback, it might have been more apparent to the DOJ, the CIA, and the entire administration that the legal arguments in the torture memos were specious and should not be relied upon. Moreover, opinions justifying something so heinous as torture might have not been written in the first place had the authors expected their work would become publicly available. In a democracy, secret law represents represents a uniquely egregious breach of public trust. Allowing legal opinions with the force of law to remain secret thwarts oversight, removes consequences for harmful agency behavior, and allows executive agencies to engage in behaviors that are counter to the will of the public they claim to serve. Furthermore, it's a longstanding practice of the Department of Justice that the Department of Justice will not prosecute people who follow OLC's legal advice, and secret legal OLC opinions are a get-out-of-jail-free card for the practitioners of unconscionable abuses. The good news is that Congress can end this perverse incentive and remedy the secret law problem. By ensuring greater transparency in OLC opinions, Congress can protect its own oversight capabilities, incentivize OLC attorneys to produce high-quality legal analysis, reduce the frequency of criminal acts performed under the color of law, and ensure that every member of the public understands what laws the country is actually operating under. This doesn't remedy every problem created by the existence of OLC opinions, but it does bring the opinions into the light of day. Our recommendations are that OLC opinions should be available to the public. Publicly releasing the OLC opinions is consistent with a letter signed by a bipartisan group of 19 former senior DOJ officials, many of whom served in the Office of the Legal Counsel, one of whom, Chris Schroeder, is the current nominee to lead the office. We note that OLC opinions are rendered as both formal opinions and informal advice. Both constitute legal advice, follow a formal approval process, have precedential value within the OLC, and are tracked in an OLC database, and both should be publicly released. There may be some instances where there are substantial reasons that certain contents of these opinions can't be released to the public. In those circumstances, the reasons for withholding should be acknowledged to Congress so that it can follow up and exercise its oversight responsibilities. The strong presumption should be in favor of public disclosure. DOJ should also publish a publicly available, machine-readable index of all currently controlling OLC opinions. This should include, for each opinion, the full name of the opinion, the date it was finalized or revised, each author's name, the recipient's name, a unique identifier assigned to each final or revised opinion, the format of the opinion, and whether the opinion has been withdrawn. At the very least, Congress and the public should know how many OLC legal opinions exist. We recommend that you once again include language concerning the Department of Justice that was contained in the report, House Report 116-455, that accompanied the Commerce, Justice, Science, and Related Agencies Appropriation Act for fiscal year 2021. To ensure an informed public, to protect against secret law, and to allow Congress to exercise its oversight responsibilities, OLC legal opinions must be made available to the public in Congress. Thank you again for the opportunity to speak here, and I welcome the opportunity from any members of Congress to answer questions that they might have. My contact information was along with my submitted testimony. Thank you.
Thank you so much, Ginger. That was very timely and important testimony. Our next presenter is Nan Swift, a resident fellow of R Street Institute. Nan, you have the floor.
Thank you, Taylor, and thank you to Demand Progress for hosting this alternative forum for members of the government accountability community to share publicly their FY22 appropriation requests in lieu of the typical House Appropriations subcommittee process. There are few opportunities for direct participation in the federal appropriations process for those outside of the federal government, and it is important to maintain this practice. My name is Nan Swift, and I am a fellow with the R Street Institute's governance program. Previously, I was a staff member for the Senate Budget Committee's Republican staff and Federal Affairs Manager for the National Taxpayers Union. The R Street Institute works to promote free markets by pursuing pragmatic, often bipartisan policy solutions to some of our most pressing issues. However, we've all seen time and time again that even the best ideas cannot get off the starting blocks due to congressional dysfunction. Good policy starts with good governance, restoring the rightful role and effectiveness of our government's first branch. In order to do so, Congress and the agencies that support it must receive the resources they need to keep pace with the size and scope of our federal government. One of those agencies is the Government Accountability Office, or GAO, which celebrates its 100th birthday this year. It plays a key role in helping Congress execute its primary responsibility, the power of the purse. Without the constant oversight and vigilance of the GAO, Congress would have a poor understanding of what happens to taxpayer dollars after the ink is dry on the latest appropriation. The GAO is Congress's watchdog, sniffing out misuse of funds and recommending reforms that could lead to better outcomes and less wasteful spending to the tune of tens of billions of dollars a year. As the federal government has grown, the GAO's work is an increasingly essential an increasingly burdensome task. Unfortunately, the funding they need to maintain a suitable, sustainable workforce has not been expanded in line with the level of work they are expected to perform. For nearly 2 decades, Congress has not responded appropriately to the conflict between congressional demands and understaffing, a situation that is exacerbated when massive new programs and spending come online during emergencies like the current COVID-19 pandemic or the 2008 financial crisis. This trend has troubling implications for Congress's ability to conduct oversight and make informed spending and policy decisions. As the mandates and requests from Congress continue to outpace the GAO's resources, it will necessitate prioritizing only those requests directly from committees or subcommittees. This will hamstring access to information for less powerful members and limit their ability to engage in the public policy process. This is already a critical problem that the House Select Committee on Congressional Modernization has tried to address. In addition, the career pipeline at the GAO will suffer from lack of expertise and diversity without a consistent flow of new staff. The legislative branch has, for many years, been the poor cousin of appropriations. It is in some ways laudable that members of Congress often set a prudent fiscal example within their own offices and committees. However, this chronic underfunding has led to many problems that hinder congressional capacity, GAO overwork among them. As the first branch, Congress should not undermine its own effectiveness as a body. Luckily, increasing legislative branch funding so that congressional staff, the GAO, and other support agencies can meet their responsibilities does not require breaking the bank any further or complicated reshuffling across budget functions. Every year, the GAO itself identifies reforms that could provide billions of dollars in savings that would be more than sufficient funding to enhance congressional capacity and improve governance. Instead of simply increasing spending across the board, Congress should enact GAO recommendations and re-examine funding priorities to make sure that the watchdog can keep up with the federal system it guards. As the first branch, Congress should not be getting appropriators scraps. Thank you again to Demand Progress for hosting this important event and providing the opportunity to testify. Thank you.
Thank you, Nan. That was great testimony. Given the Swift last name, a good name. Thank you. Our next speaker is Brian Baird, former member of Congress from the state of Washington. Brian, you have the floor.
Thank you, Taylor. Distinguished members of the committee, colleagues, and friends, thank you for the opportunity to testify before you today on a matter of truly profound importance, the continued existence and legitimate functioning of the Congress itself. I know this committee, oh, sorry. All right, can you see me now, Taylor?
Yeah, you're good. Thanks, Brian.
My apologies. I'm back to it. Distinguished members of the committee, colleagues, and friends, thank you for the opportunity to testify before you today on a matter of truly profound importance, the continued existence and legitimate functioning of the Congress itself. I know this committee will receive countless funding requests, but I urge you to make a relatively small amount of funds available in the budget and in appropriations to ensure that the Congress, the executive branch, and the judiciary will all be able to function even and especially in times of grave national crisis. If there is a more important or fundamental or consequential use of funds, I'm not sure what it could be, but I am absolutely certain that this matter must be addressed and resolved. As it stands now, none of the three branches of our government has in place viable, constitutionally valid, and practical procedures to ensure their continuity under circumstances that are entirely feasible and possible, and in fact have nearly come to pass. As described in great detail in the 3-volume report by the Nonpartisan Continuity of Government Commission that was formed after the attacks of September 11, 2001, these vulnerabilities pose an existential danger to this institution, to our democratic republic, and quite frankly, to each of you individually as members of Congress. The truth is, Congress is woefully unprepared to manage an attack or pandemic that kills or incapacitates large numbers of members. What is more, the very real possibility exists that deaths from disease or worse, from targeted assassinations of even as few as a single member, could alter the political and ideological makeup of the institution. The experience of the COVID-19 pandemic and the attacks of January 6th should amplify the urgency of this matter. Congress simply must act as quickly as possible to study the threats and shortcomings to continuity and then implement solutions not only for itself, but for the other branches of our government as well. This is in your personal best interest, and it is vital to the national interest. To accomplish this, it's recommended that Congress establish a bicameral, bipartisan select committee to study and report recommended continuity solutions for action by both chambers. This request is for funding sufficient to provide the establishment, staffing, and activities of the proposed committee for the coming fiscal year. At the beginning of each Congress, we all swear an oath to uphold and defend the Constitution. If we knowingly leave all three branches of our constitutional government vulnerable to terrorist attacks, assassinations, or natural calamities, we have failed to uphold that sacred oath. I'm here today asking you to fulfill that oath by dedicating the necessary resources to solve these continuity shortcomings once and for all. Thank you for your consideration. I wish you speedy action on these vital measures. Thank you.
Thank you, Brian. That was fantastic. And I speak for many on this call, on this webinar, that you have a voice made for radio and podcasting. You should definitely look into it. That was great. Thank you. Our next speaker is going to be Michael Stern, founder of Point of Order. Mike, if you would like to turn your camera on, and you have the floor.
Thank you very much. Thank you for the opportunity to submit this testimony today regarding the FY 2022 budget request of the Office of General Counsel of the U.S. House of Representatives. I am Michael Stern. I formerly served in various capacities on the Hill as a lawyer and staffer. Most relevantly to today's subject, I served from 1996 to 2004 as senior counsel in the Office of General Counsel, where I handled a broad range of matters for the House. Since then, I've written on numerous congressional legal issues, including at the Point of Order blog, and have worked with various groups interested in congressional capacity, reform, and transparency. Today, I will address the need for an enhanced public-facing role for the Office of General Counsel and greater transparency for its activities and those of the Bipartisan Legal Advisory Group, which advises the Speaker on the functioning of the Office of General Counsel and is responsible for articulating the legal position of the House in all litigation matters. While OGC has a website with some information on areas of the law most relevant to its practice and some information on legal briefs that's filed, this information is largely general in nature and does not appear to be frequently updated. Moreover, BLAG itself has no website at all, and there appears to be little, if any, information about its activities in any House source. This lack of transparency is particularly concerning because it is in the House's institutional interest for the public to have more information about its legal opinions and positions and how they are formulated. A member of the public trying to understand how the House develops its views or what the House's views are on important legal controversies would find it very difficult to do so. Legal scholars and commentators are similarly disadvantaged by the lack of access to the opinions of the House's most knowledgeable legal experts. By contrast, the Justice Department's Office of Legal Counsel maintains a website in which its numerous legal opinions in support of executive power can easily be accessed. This imbalance of information undermines the House's institutional legal positions in court and with the public, particularly on oversight and other separation of powers issues where it frequently clashes with the executive branch. In my written testimony, I have provided some brief history of the Office of General Counsel, how it originated, as well as the BLAG. But for present purposes, the basic point is that OGC's functions and methods of operation have been developed through practice and informal understandings over time. For example, OGC is required, or at least during my time of service was, to provide notice of subpoenas to House officers, to the Speaker, the Minority Leader, and to the parliamentarian, an informal process that is known as the Three Amigos. Many of these functions and practices of OGC are similarly unwritten and informal, and are not known even to many members of the House, much less to the general public. As for BLAG, during my tenure, the only formal existence of that body consisted of a single reference in the House rule establishing the Office of General Counsel. Since that time, the House rules have been amended to provide that BLAG speaks for and articulates the institutional positions of the House in litigation, but there is, to my knowledge, no public information about how BLAG exercises that responsibility, whether it meets regularly or at all, or whether there are any rules governing its deliberations, or frankly, anything else about its activities. Unlike the Senate Legal Counsel, which is required by statute to make publicly available court papers and research memoranda relating to significant congressional legal issues and court proceedings, OGC has no mandated public-facing or educational role. It does have a website, but its Notable Cases tab simply provides links to significant court decisions and a few amicus briefs filed in recent years. This information does not appear to have been updated since 2019, and other than a bare reference to BLAG's existence, there is no information about that body at all. It is in the public interest to understand more about how OGC and BLAG operate and fulfill the important functions they have under the House rules. It is also in the House's interest to educate the public regarding the substance of the positions it has taken on important legal controversies, and to provide some balance to legal arguments made by executive branch lawyers at the Office of Legal Counsel and elsewhere. While the House cannot compete on an even playing field with the legal resources of the executive branch, it can take modest steps to improve its outreach and communicate more effectively with the public. Accordingly, I urge the subcommittee to ensure that OGC's funding for FY 2022 is sufficient to enhance its capacity to improve its website and provide important legal information to the public. It should be directed to expand its website to provide non-privileged information about its legal advice and representation, including court filings, legal opinions, and select explanatory or historical documents that would shed light on its operations and the legal views of the House. It should also include basic information about the BLAG, such as a description of what BLAG is, who serves on it, how it functions, and instances where the BLAG authorizes or directs the OGC to provide legal filings in court. Thank you again for the opportunity to submit this testimony.
Thank you so much, Mike. Very important testimony and presentation. For those wondering, yes, Mike and I did coordinate our outfits. So just so everybody's aware. Our next speaker is Daniel Schuman, Policy Director for Demand Progress. Daniel, you have the floor.
Thank you. So today I'm going to address the question of unionization of congressional staff. Congressional staff work hard and under very difficult circumstances. This has always been true, but the last year has been particularly traumatic. Staff survived the insurrection, are slogging through the COVID pandemic, and are shouldering dramatically increasing workloads and heartbreaking requests for assistance. These recent and ongoing experiences continue to take a mental and physical toll on staff. Many have reached, and some have passed the breaking point. Business Insider reported that many experts believe that exhaustion and trauma are pushing qualified people out the door, exacerbating the long-running problem of brain drain on Capitol Hill, while denying lawmakers talented staff as they try to tackle some of the most pressing issues to face the country in generations. This is an acceleration of already troubling trends. House Majority Leader Steny Hoyer recently said, "Each year we lose talented and experienced staff with deep institutional knowledge to the private sector because we do not offer competitive compensation and benefits." House Administration Committee Ranking Member Rodney Davis sounded a similar note. You can't always say, let's put the Congress first, because you're going to have to put your families first. That's a decision I don't want to see staffers have to continue to make. Congress has begun to acknowledge the difficult circumstances for staff. Many committees have issued recommendations or proposals are improving the quality of life for staff, but the need for these reforms in the long list of reforms also indicates the current state of affairs. The feedback mechanism for reform is too slow, and the signal received by Congress is too weak to timely address staff distress. One traditional way that employees work with employers to address their needs is through unions. As President Biden recently declared, we must always protect the right of workers to unite and bargain for their own mutual aid or protection. This is an avenue open to Congress, even if the history of the prior effort to allow for unionization has largely been forgotten. In 1995, Congress enacted the Congressional Accountability Act. That law applied 11 federal labor laws to Congress, including the right to unionize. It was a culmination of a 5-year bipartisan effort to, quote, make Congress subject to the laws it passes, unquote. The Congressional Accountability Act allows staff to form, join, or assist a labor organization for the purpose of collective bargaining without fear of penalty or reprisal. But the CAA created a 2-track system for unionization. The first track allowed certain legislative branch agencies and support staff to unionize, such as employees of the Capitol Police, the Library of Congress, the Government Publishing Office, and others. The second track would allow for personal and committee staff to unionize, as well as some support office staff. However, they could do so only after the Office of Compliance promulgates a regulation and the proposed regulations are adopted by the House or Senate. The Office of Compliance Board issued regulations that would apply to second-track staff in the House and in the Senate way back in 1996, but though would only require the passage of a simple resolution, neither the House nor the Senate put the regulations into effect. This is where matters stand a quarter century later. The time is right for Congress to revisit the issue and examine the feasibility of allowing unionization in congressional political offices. We urge the House to direct the Office of Congressional Workplace Rights to issue a report that evaluates the fitness and implications of implementing the regulation concerning unionization of personal, committee, leadership, and support staff. Congressional staff are essential to Congress's success, but Congress is failing its staff. We believe the House and Senate must consider providing its staff the ability to collectively advocate for measures that improve the operations of the Congress and the lives of those who serve in it. Thank you very much.
Thank you for that testimony, Daniel. Very important issue, especially given the last year. Our next presenter is Jamie Neikrie from Issue 1. Jamie, you have the floor.
Thanks, Taylor. And thank you to Demand Progress for organizing this alternative witness testimony. My name is Jamie Neikrie, and I am testifying on behalf of Issue 1 and on behalf of our Executive Director, Meredith McGehee. For the Legislative Branch Appropriations Subcommittee, we hope that this testimony is a helpful addition to the written testimony that we submitted earlier this month. Issue 1 is a leading nonprofit and cross-partisan reform group based here in Washington, D.C., and our mission is to fix democracy first. Central to that mission is our commitment to seeing a Congress that is effective, transparent, functional, and representative. And I want to discuss 3 issues today, 3 appropriations requests that are all geared at ensuring that we have a Congress that is upholding its responsibilities to the American people. The first issue is about staff pay and retention, which builds nicely on what Taylor just discussed. As you heard Daniel say, staff are crucial to the daily operations of Congress. They craft policy, they enact legislation, and they interact with constituents. And having a capable and diverse staff isn't about supporting members, it's about supporting constituents. Despite the wide range of responsibilities and challenges placed on congressional staff, They are paid less than their counterparts in the executive branch and in the private sector. Specifically, House staff are only paid once per month. This kind of pay cycle exacerbates financial instability and challenges workers in times of financial emergencies. Changing to a twice per month pay cycle, which is one of the recommendations made by the Select Committee on the Modernization of Congress, would help ensure that staff are being supported in the best way possible, and it would also bring Congress in line with modern payroll best practices. Issue 1 recommends that the Chief Administrative Officer update the staff payroll system to semi-monthly by the end of the fiscal year. To continue with this issue, pay isn't the only thing that impacts the ability of Congress to attract and retain staff. For every staff member that leaves because of pay, there's another that leaves because of a poor working environment or bad management. And these issues are especially salient for staff of color, many of whom too often find themselves in exclusive or unwelcoming spaces on Capitol Hill. Now, the Congressional Staff Academy, which is an initiative of the CAO, can help address a lot of these challenges and is already by providing training for members, chiefs of staff, and others in leadership positions. And they're also doing diversity and equity training. But in order to continue these efforts, the CAO just needs more money. It just doesn't have enough money to meet all of the demands placed on it, many of which have grown during the pandemic. And for fiscal year 2022, CAO requested an 8% increase in funding, which would allow the office to continue providing these crucial trainings. Issue 1 echoes and supports the CAO's request. As a final recommendation to the subcommittee, I want to shift focus slightly to an equally important issue of congressional capacity, which is the question of how this institution responds to and learns from the events of January 6th. The January 6th insurrection exposed vulnerabilities in our nation's ability to predict and respond to domestic terrorist attacks. It highlighted Capitol security concerns, and it raised questions about Congress's ability to ensure continuity of the legislative body had the worst occurred. You just heard Baird, Congressman Baird, discuss a lot of these issues. Issue 1 urges Congress to establish a national commission which would be tasked with investigating the events of January 6th, making recommendations to prevent future attacks, and strengthening the resilience of this democratic institution. This commission should be truly bipartisan, with equal numbers of Republicans and Democrats, and it should be sufficiently funded and staffed to meet its obligations. In our request, Issue 1 recommended a funding level of $10 million, which is comparable to the funding levels received by the 9/11 Commission. Taken together, these 3 recommendations will help ensure that Congress is capable of meeting its responsibilities and commitments to the American people. Issue 1 stands ready to provide assistance, expertise, and information to the subcommittee. Thank you.
Thank you for that comprehensive presentation, Jamie. That's a lot of really important issues that you brought up. Our next presenter is Amelia Strauss, a great colleague of mine. She's a policy advisor for Demand Progress. Amelia, you have the floor.
Thank you, Taylor. My testimony today concerns transparency and accountability practices of the U.S. Capitol Police. I'd like to start by noting that legislative branch appropriators have been out front on efforts to both reform the Capitol Police and to build a stronger, safer, and more democratic legislative branch. Look no farther than the slate of recommendations included in last year's appropriations bill, aimed at enhancing access to information, addressing concerns of discrimination, and studying policing overreach, not to mention the panel's recent hearings. An effective Congress is secure and accessible. The Capitol Police are an integral part of maintaining this delicate balance. The department has extensive resources to execute its mission. It received more than $500 million in funding for fiscal year 2021 and requested over $100 million increase for fiscal year 2022, which does not include supplemental security funds. Legislative branch funds are extraordinarily constrained, and the portion of those dollars going to Capitol Police has grown dramatically, from 3% in 1995 to nearly 10% in 2020. With an abundance of resources at its disposal and a vital mission, the stakes of which are unfortunately more evident than ever, we must make certain the department is transparent, accountable, and responsive to Congress, the press, and the public. To that end, I've submitted 5 recommendations to appropriators. I will focus my remaining time on the first 2, creating an independent stakeholders committee and establishing an information request process. Capitol Police currently reports to the U.S. Capitol Police Board, the board which is composed of the sergeants at arms, the architect of the Capitol, and the Capitol Police Chief as an ex officio member, is insular, risk-averse, reactive, and unaccountable. The primary incentive for the board is to defer to the chair and to operate by consensus. This means many important issues are left unaddressed or unresolved. Notably, in 2017, GAO found most congressional stakeholders expressed concern regarding the board's accountability, transparency, and communication approaches. GAO has also reported that the board failed to implement 2017 recommendations or answer GAO follow-up requests for information. Reform is more likely to occur when information is out in the open. We therefore propose establishing a separate and independent stakeholders committee to oversee Capitol Police, comparable to the independent civilian oversight boards that many large police departments nationwide have. We recommend GAO study the feasibility, structure, and associated costs of creating an independent stakeholders committee. This stakeholders committee could represent the interests of members of Congress, congressional staff, Capitol Hill essential workers, support office and agency staff, journalists, lobbyists, the general public, and of course, Capitol Hill neighbors. Representatives from those categories could hold public meetings, post public minutes that summarize meetings content, and solicit public comments. The Independent Stakeholders Committee must be fully independent of the department and the board to be successful. To that end, members should be compensated for their time and provided staff when appropriate. Our second recommendation is to establish an information request process. In the House report accompanying the fiscal year 2021 Legislative Branch Appropriations Bill, appropriators encourage the Capitol Police to develop a policy and procedure for the sharing of information that follows the spirit of the Freedom of Information Act. We strongly support this request because the department has yet to stand up an official process for responding to public requests for information of its own volition. And as a legislative branch agency, the department is not subject to FOIA or records laws, unlike most of its security agency and law enforcement peers. The department has indicated it is unwilling to respond to the press or communicate with the public. For example, on February 25th, Acting Chief Pittman testified before appropriators that she would not commit to having public press briefings in the future. We do not know whether the Capitol Police has complied with appropriators' directive to develop a FOIA-like process, or whether the department is consulting with experts from civil society or government. Our experiences with the department suggest that additional requirements are needed from appropriators to ensure the request is implemented and implemented correctly. We respectfully suggest appropriators request the Capitol Police develop a policy and procedure for the sharing of information that follows the spirit of FOIA and closely adheres to the language of FOIA. The request should include a clear deadline for creation and implementation of the procedure, and the procedure should apply to both the department and the board. The procedure should include provisions for review external to the Capitol Police. This will allow requesters to appeal to a disinterested third party. We also recommend that Capitol Police consult with relevant stakeholders like civil society, governmental FOIA experts, and congressional peers in the process of developing regulations. The best way to support the Capitol Police, Capitol safety, and the work of Congress at large is through improved oversight protocols. Expanding access to information can only help the Capitol Police and Congress. This concludes my testimony. Thank you for the opportunity.
Thank you for that presentation, Amelia. Very, very important topic that I know you have been working on for years. Our next presenter is Bradley Moss, who is the Deputy Executive Director at National Security Counselors. Bradley, you have the floor.
Thank you, Taylor, and thank you, of course, Demand Progress for providing this opportunity, and thank you for the committee for considering this testimony on this particular request for appropriation. My name is Brad Moss. I'm a private attorney here in the DC area, specializing in national security employment matters and information transparency, particularly through FOIA litigation. Among the various hats I hold from an employment context, in the one I am testifying here today is as Deputy Executive Director for National Security Counselors, which is a law firm specializing in information transparency through FOIA litigation. The purpose of my request today here for appropriation is a rather small and narrow and modest one. Quite simply, we are seeking to have a study done of all in-camera ex parte declarations filed by U.S. government agencies in FOIA litigation. We would want to have this presumably run through the administrative office of the U.S. courts, and presumably would encompass probably the last 5 to 10 years. What we would want to seek is to identify all the total number of declarations, ex parte in-camera declarations that were filed, which courts they were filed in, which agencies were behind the filing, whether or not the U.S. government sought leave of the court to file them or simply did so as a matter of alleged right. And lastly, the extent to which the in-camera declarations relied on factual information distinct from public filings as opposed to simply legal arguments. As part of the study, we would also want an assessment of the feasibility of a process by which formally in-camera declarations could be filed on the public record and made available just like all other public filings are done in civil litigation. The reason we want this study is quite simply we need raw data to be able to determine whether or not to come before Congress to propose potential legislative reform to FOIA with respect to the use of in-camera declarations. I'm assuming by and large everybody knows how FOIA works and knows that the burden initially is on a government agency to justify any redactions or withholdings they may make to records that are otherwise responsive to a FOIA request. In-camera declarations are not embodied in the statute, but are rather a matter of judicial interpretation that preceded FOIA and has been incorporated into it by the courts, not necessarily by Congress. The purpose behind an in-camera declaration, of course, is where an agency has no other means to provide the court with the explanation, the factual descriptions of harm that would be caused if information is otherwise disclosed, and provides that in-camera in addition to a public affidavit. It is our view that despite the fact that the courts will always pay lip service to the idea that these in-camera declarations are only supposed to be provided when truly necessary, despite the lip service to the idea that the public filing should be as full and complete as possible, that these in-camera declarations are being more and more incrementally used and somewhat abused with respect to the adversarial process that underlies civil litigation, particularly in FOIA. I personally have experience handling a number of FOIA cases where there have been in-camera declarations filed that have essentially been the entire case, where the public pleadings, the public declarations filed by the agency are rather vague and simplistic and just repeatedly cite back to the in-camera declaration. Of course, as the litigant for the opposing party, I don't have access to the in-camera declaration. I have no idea what the government's been arguing there, and I'm left, with a tactical disadvantage. One prominent example of this was I was primary counsel for FOIA litigants in a case that was a matter of public notoriety, the memoranda crafted by former FBI Director James Comey several years ago, where he documented his interactions with then President Donald Trump. Once the media reporting came out that it described the existence of these memos, a number of FOIA requesters, including in my case, USA Today and journalist Brad Heath, submitted FOIA requests and sued to get access to those memos. The government claimed the entirety of those memos had to be withheld because it would harm an ongoing law enforcement investigation. Of course, that was Robert Mueller's investigation. But to justify this, the government relied almost exclusively on information in-camera ex parte declarations. Even the judge noted that the public declarations were vague and rather tight-lipped and simplistic, but ultimately ruled in favor of the government only after demanding additional declarations from the government, all in camera, including from Robert Mueller's team, and conducting an in-camera review of the documents himself. While that is what we always wish for and strive for in this type of situation in FOIA where there's in-camera filings, it is not what would normally happen. It is the exception, not the rule. And it's not necessarily how this process is supposed to work. And it's not the burden of the judge to always have to handle that. It's supposed to be an adversarial process where both sides are able to present their arguments. But the use of the in-camera filings here has undermined FOIA litigants' ability to do so. It is for that reason that we want this study to get this information to and decide whether or not there is a legislative reform that we want to propose and bring to Congress for its consideration, whether it be codifying and outlining a more streamlined process by which in-camera declarations are filed and what's required of agencies, and whether or not, just like how Congress recently did in FOIA with respect to deliberative process privileges lapsing after 25 years, whether or not there should be a process set up by which in-camera filings after a certain number of years set by Congress are automatically filed on the public record and no longer kept in camera and ex parte, with obvious caveats, of course, for case-by-case situations where the government would be able to argue otherwise. That is the reason for our request for appropriation. We request that you take this under consideration and stand ready to answer any questions the committee might have about it. Thank you.
Thank you for that presentation, Brad. Very comprehensive presentation there. We have 3 more presenters on our list. Next up is Irvin McCullough, a national security analyst for the Government Accountability Project. Irvin, you have the floor.
Thanks so much, Taylor. And thank you all for the opportunity to speak about creating a resource vital to Congress's oversight responsibilities, a whistleblowing resource center for the United States Senate. Representatives from civil society have previously testified before this committee about the need to establish an office to support House staff who work with whistleblowers. We were all glad when the House agreed to establish such an office. I'm here now to implore you all to help those across the street inside the United States Senate. Whistleblowers are Congress's lifeline to information about federal waste, fraud, abuse, and malfeasance. Before the False Claims Act gave whistleblowers the right to challenge fraud in federal contracts, for example, the Department of Justice recovered less than $10 million in fraud each year. The department now recovers an average of $3 to $5 billion annually through whistleblowers' use of the False Claims Act alone. From spotlighting ill-equipped armored vehicles to saving millions lost in mismanagement each year, whistleblowers protect our lives and taxpayers' pocketbooks. But they do so, they go against a giant bureaucracy, and they can lose everything in the process. Congressional intervention provides a lifeline in turn for protecting whistleblowers. Through an effective partnership, congressional offices and committees can help shift the pressure from the isolated whistleblower onto a corrupt institution, while receiving information necessary to fulfilling the legislative branch's oversight responsibilities. The creation of the House Whistleblower Office, the House Office of the Whistleblower Ombuds, was an important starting point to ensure that whistleblowers have the necessary confidence that their claims will be handled responsibly. It's been an astounding success. Members and staff from both sides of the aisle are effusive in their praise. As someone who's historically been brought in to train many committee staffers on best practices when working with whistleblowers, their work's not only given me a nice break, they've accomplished more in their specialized congressional trainings than either I or my colleagues ever could. Now it's time to repeat the success in the Senate. Not one argument has changed. This office is as necessary in the Senate as it was in the House. It will be as effective in the Senate as it has been in the House. It will be a godsend to whistleblowers, members, and staffers alike. And that's why we appreciate your thoughtful consideration and look forward to working with you, the audience, and the United States Congress on charting this path forward. Thank you very much.
Thank you, Irving. Really interesting and important topic, especially since one chamber has it already. Our next presenter is Andrew Lautz, the Director of Federal Policy for the National Taxpayers Union. Andrew, you have the floor.
Thanks so much, Taylor, and it's a pleasure to follow Irvin, especially when we strongly agree with the request they're making today. So thank you again. My name is Andrew Lautz, and I'm the Director of Federal Policy at National Taxpayers Union, the nation's oldest taxpayer advocacy organization. It's a pleasure and privilege to join our colleagues at Demand Progress and from organizations across the ideological spectrum at this webinar today. And I'm pleased to testify on 2 fiscal year 2022 appropriations requests affecting the Office of Management and Budget, apportionment reform, and updated criteria for the Overseas Contingency Operations, or OCO account. As some listeners may know, the Office of Management and Budget plays a critical role in managing taxpayer dollars. OMB handles the release of and messaging around the President's annual discretionary budget request, reviews economically significant regulations being promulgated at the federal agencies under the President's purview, and controls, to some extent, when and how congressionally appropriated dollars are sent to the federal agencies. It is the latter responsibility that concerns the first of two FY 2022 appropriations requests NTU is making today. OMB has the responsibility of regularly apportioning congressionally appropriated dollars. In other words, the agency must release appropriated funds for use by the federal agencies tasked with spending certain taxpayer dollars. Unfortunately, OMB's decision-making process currently operates in something of a black box, making it difficult for government and non-government watchdogs to ensure OMB is playing a fair, efficient, and even-handed role in apportioning congressionally appropriated funds. We are requesting that the Financial Services and General Government Appropriations Bill include report language asking OMB to study the feasibility, cost, benefits, and drawbacks of developing a public website at OMB to report all apportionment decisions in a timely and transparent manner. Fortunately, there is already bipartisan support for making such information publicly available. An amendment added to the Bipartisan Congressional Budget Reform Act in the 116th Congress, supported by a bipartisan set of lawmakers, would require OMB to report every apportionment of congressionally appropriated funds on a public website. It would also require OMB to report to Congress every time an agency requests appropriated funds that haven't been approved by OMB in a timely fashion. Similar provisions are included in the Congressional Power of the Purse Act from the 116th Congress, which the House Committee on the Budget actually just held a hearing on yesterday in the 117th Congress. Given the inherent limitations of the appropriations process, we are hoping to advance progress on this important initiative by requesting a report from OMB on the costs and benefits of developing this website. Some stakeholders have raised concerns about the costs or administrative burdens such a public website requirement might put on OMB. A report from the agency could provide further clarity on these concerns, though Congress should ultimately have the final say on the matter rather than OMB. In this requested report language, we also ask OMB to determine how many additional personnel might be required to accomplish this task. This will help both government and non-government watchdogs determine what kind of burden OMB thinks developing and updating a public website would put on the agency, and may help Congress ultimately craft apportionment transparency requirements that are easy for the agency to implement and easy for the public to access and understand. We believe that lawmakers of both major political parties should, once again, be able to coalesce around this reform option. Whether a Republican or a Democrat is in charge of the White House, we believe Republicans and Democrats in Congress can both agree that Congress has the proper constitutional authority over federal tax and spending matters, in other words, the nation's purse strings. Requiring a modicum of transparency from OMB on its apportionment decisions is just one step Congress can take to reclaim its power of the purse. Our second appropriations request involves OMB as well, but would focus on the Department of Defense appropriations bill. We are asking for report language that requires the Undersecretary of Defense, the Comptroller, to, in coordination with OMB, deliver to Congress and post on a public website a report on the governing principles of the Overseas Contingency Operations Account, or OCO. The OCO designation and the related Global War on Terror, or GWOT, budget designation has been around since the early years of the Iraq War and the War on Terror. For many years, but especially in the past 7 to 8 years, the OCO account has become a slush fund for defense priorities that have little or nothing to do with the emergency overseas needs the account was created to fund. One study by NTU counted $164 billion in OCO funds that were dedicated to non-OCO programs over the past 7 fiscal years, an extraordinary amount of taxpayer waste and slush. Part of the problem is that neither OMB nor the Department of Defense have even updated their criteria for what's to be included in the OCO account since 2010, despite long-standing recommendations from the Nonpartisan Government Accountability Office to do so. While the urgency of this request is somewhat muted by the Biden administration's reported elimination of funding for the OCO account, we believe OMB and DoD should still update their criteria should either Congress or the Biden administration or some future administration try to revive OCO. Our report language would require, at a minimum, a 5-year projection of OCO costs under the revised criteria developed by the department. This will help taxpayers understand whether or not military leaders expect OCO to make a return in the near future. I wish to thank listeners for their consideration of our request today and demand progress for the opportunity to participate in this webinar and offer some context on our recommendations. Thank you.
Thank you, Andrew. That was extremely comprehensive in less than 5 minutes, so great job. Our last speaker, but certainly not least, is McClanahan, the Executive Director of National Security Counselors. Kelly, you have the floor.
Thank you, Taylor, and thank you, Demand Progress, for hosting this. And I echo the sentiments of all of my fellow presenters when I thank everyone who's viewing this for considering this testimony in this time when we can't be there in person to answer your questions. I'm here today to present, much like my colleague, Mr. Moss did, fairly modest proposals that will increase effective oversight by Congress and the public of the intelligence community. The first one is with respect to the Government Accountability Office, which you have heard many people talk about before. It's also about the Office of Legal Counsel. So in some ways, this testimony is best to come last because it incorporates so many themes of what we've been talking about so far. By statute, GAO has the purview to conduct oversight of all federal agencies. And it has, since it was created in 1921, 100 years ago this year, as was noted before. However, the intelligence community has pretty much since its inception insisted that it is not subject to GAO audits. And as Ms. Swift noted, this basically deprives Congress of one of the most effective tools in its arsenal at a time when the activities of the intelligence community present some of the most pressing needs for robust oversight of the executive branch. This has been attempted to be fixed by Congress many times in the past. Then Congressman Leon Panetta tried to fix it in 1987 with the CIA Accountability Act. That did not get passed. In 1988, GAO attempted to conduct an investigation of what could go into U.S. foreign policy decisions. And the National Security Council asked the Office of Legal Counsel for an opinion that has been cited pretty much ever since, that concluded that not only is GAO not authorized by statute to pursue the investigation, but we believe that GAO is specifically precluded by statute from access to intelligence information. And they based this bizarre ruling on the idea that since the intelligence committees were created by Congress, that only the intelligence committees can oversee GAO. This fight keeps going. In 2010, there was a provision put into the FY 2010 Intelligence Authorization Act that prompted a veto threat and prompted the then acting Comptroller General Dodaro to say that there was no legislative history that would support the position taken by the intelligence communities, and that resistance has greatly impeded GAO's work for the intelligence committees and also jeopardizes some of GAO's work for other committees of jurisdiction, including armed services, appropriations, judiciary, and foreign relations. Despite this, Congress decided to give the executive branch one more chance, and they tasked the DNI with developing a regulation for how to deal with GAO. The DNI put in Intelligence Committee Directive 114 that said what they had been saying all along. The information that falls within the purview of the Congressional Intelligence Oversight Committees cannot be made available to GAO. So GAO can investigate anything that the intelligence committees cannot, which is nothing for the most part, because the intelligence committees can investigate anything. So you have this going on for the last 3 years at least. Mr. Dodaro has been talking to Congress about the need for the continued support of the intelligence committees in helping him with the intelligence community. But even then, that doesn't work. You have regulations like CIA regulation AR 13.5 that says that if GAO makes a request on behalf of an intelligence committee, that the agency will not give it the information. And it will just give the information directly to the committee. Either way, GAO never gets the information, which is insane. Simply speaking, GAO has more cleared personnel at the top secret sensitive class compartmented information level than all of the staffers of both intelligence committees put together. They have institutional expertise. They have the ability to do this. And what we're asking would be revenue neutral the best part of an approach ask, because we're not asking for GAO to take on any other job than it could already do. With that, I would refer everyone to my written testimony, and thank you all for coming.
Thank you, Kel. Very comprehensive as well. That concludes all of the presentations from our speakers today. I want to thank all of the presenters for their time, expertise, analysis, and thank all of the attendees for attending this webinar. This has been an opportunity to allow everybody to present their public witness testimony for the appropriations subcommittees. We will make sure to provide a copy of this webinar on our website and our YouTube pages for further viewing. And thank you to everybody, and have a wonderful day. Bye.